Thank you, everyone, for coming out today. My name is Brandy Lupo, and I'm the Outgoing Communications Director for RegBlog.
And my name is Eric Slabs, and I'm the incoming Managing Editor.
Before we get started, we want to thank the Penn Program on Regulation, the Federalist Society, the American Constitution Society, and a special thank you to Ann and Gavin for making this event possible. This month, we celebrate RegBlog's 5th anniversary. Our founding year, 2011, was a big year in regulation. Citizens United was only a year old, and the Supreme Court had just granted Cert in its first Obamacare case, Sebelius.
And since then, RegBlog launched, and we've grown in terms of student contributors, outside contributors, and the scope of our regulatory coverage. And with that, I'd like to welcome Professor Kerry Colanesi to introduce the panel, and he launched RegBlog. RegBlog is his brainchild, and we can't thank him enough for everything he does.
Well, thank you very much, Eric. Thank you, Brandy. Thank you for all of the members of the RegBlog family for all that you've done to bring us together here today. It was actually 5 years ago to this very day that students at Penn Law gathered in the GOAT area and actually celebrated the launch of RegBlog on our platform. And for 1,305 weekdays ever since, Penn Law students who run RegBlog have been writing, editing, and publishing new content on RegBlog. It's actually been 134 students in total over the years, just these few years. While they've written much of the content, we've actually had the privilege of publishing the work of other scholars and practitioners. Actually, among the 210 outside contributors to RegBlog over the years, we've had sitting judges, heads of administrative agencies, and former members of Congress. And as Brandy indicated, the last 5 years, for anybody interested in regulation, have been fascinating ones. And whether you think the value to society on balance has been positive or negative from regulation, we've seen many new forms of regulation be implemented, whether it's under Dodd-Frank, the Affordable Care Act, new statutes, or whether we've seen new regulations under old statutes, such as the initiative that the Obama administration has taken to deal with climate change under the Clean Air Act, which really was not originally passed with climate change in mind. But we really don't focus here today, here at lunch, so much on the past, but on the future. Some portend a looming constitutional moment for our government, with questions revolving around the role of government and its relationship to the economy and to society, the role of the president in overseeing the regulatory state, and to help us sort through the path forward for the U.S. regulatory state, we've assembled a very knowledgeable panel here who have focused a lot on regulatory issues over the last 5 years and even before that. And I should note that each of them in their own way has graced the pages of RegBlog over the last 5 years. So here's what we'll do today. I'll make some introductions of our panelists, then I'll invite them to answer a few questions that I'll pose and have some discussion among themselves, and then we'll open it up for your questions as well. I'm going to start on my far left, your far right, with Rena Steinzer, who's a professor of law at the University of Maryland, Carey School of Law. Professor Steinzer has been a prolific scholar of environmental law and administrative law and regulation. Before joining the Legal Academy, she represented local and state governments in environmental matters in private practice, and she served as staff counsel in the House of Representatives, where she was responsible for drafting major amendments to the Superfund law. She played a pivotal role in the establishment and leadership as president for many years of the Center for Progressive Reform. CPR boasts more than 50 scholars as members, and has become a leading voice for more stringent and effective regulatory policy, particularly on environment, health, and safety matters. Among her many books, articles, and other publications, the two that I will note of most relevance here today are the two essays she's published on RegBlog. She and I actually first met here at Penn Law as well, many years ago when I was still on the faculty at Harvard, so it's really nice to welcome you back to Penn Law Arena. Sitting to her right and to your left is Paul Noe. Paul is a Vice President for Public Policy at the American Forest and Paper Association. He's currently also our very first visiting policy fellow here at Penn Law, and he'll be lecturing this afternoon in Professor Galbach's legislation course. He comes to his current position in Washington after having government experience in all three branches of government. His most recent governmental posts include serving as senior counsel for the U.S. Senate Government Affairs Committee, as well as serving as counselor to the White House Office of Information and Regulatory Affairs during the George W. Bush administration. He's an active leader in the ABA's Administrative Law and Regulatory Practice section, a past participant in various Penn Program on Regulation events, and it's actually true that you can go see a very nice photo of him at one of those events on RegBlog. Sitting to his left is Andy Green. Andy is the Managing Director of Economic Policy at the Center for American Progress, which is a major progressive think tank in Washington, where he leads CAP's efforts on financial market reform, trade issues, and other budgetary and economic policies. Andy came to his current position after a number of years in both private practice and governmental service. In government, he served as counsel to U.S. Senator Jeff Merkley and participated in the drafting of the Dodd-Frank Act. In fact, he was the lead staff person to see that the Volcker Rule provisions were added to Dodd-Frank. He most recently served as counsel to a commissioner on the U.S. Securities and Exchange Commission. And again, Penn Program on Regulation was delighted to have his insights at a workshop we held a couple of years ago on the Volcker Rule. And again, a nice photo of him is on RegBlog. Finally, last but not least, on your far left is Sam Batkins, the Director of Regulatory Policy at the American Action Forum, a think tank in Washington devoted to building a better economic future, promoting innovative free market solutions, and creating smaller and smarter government. At AAF, Sam focuses his research a lot on regulation and the rulemaking process. He's a lawyer by training, previously has worked with the U.S. Chamber of Commerce, the Institute for Legal Reform, and the National Taxpayers Union. And he has, among our panel members, been the most frequent in his digital presence on RegBlog, having contributed an average of about 2 pieces per year over our lifespan. And we're very delighted, Sam, to have you here, not virtually anymore, but in person. So I hope you will join me in welcoming our panel members. And we'll get underway. And I'd like to ask Rena first if you could share your thoughts about the most important priorities for U.S. regulation or the regulatory process over the next 5 years.
Thank you. You deserve a tremendous amount of credit for having gotten this program. There's nothing like it in the country. So congratulations.
Thank you, Rena.
I asked Carrie what I should do, and he said, well, why don't you channel a presidential candidate? He actually suggested that I channel Hillary Clinton, but as I decided that would be too boring, so I'm going to channel Bernie Sanders. I would have 4 goals if I was elected president for the administrative state. The first thing I would want to do would be to accomplish something. After all, Hillary Clinton says, I don't want to accomplish anything. I'm just a flake who likes to talk rhetoric. And I'd want to prove her wrong. I'd want to accomplish something. And I would pick, with single-minded focus, climate change, which is, I think, scientists, all the scientists would agree, the most urgent problem that faces mankind. Now, what do I mean when I say single-minded focus? I would talk about it all the time. I would be prepared to sacrifice big political chips to make progress on it. Depending on how Congress was, I would either try to avoid them or I would demand that they do something very active about this problem. And I would have two messages that are somewhat different than the messages we've heard in the immediate past. One is that it's coming much faster than we think, that if we don't do something about it urgently, there will be great suffering throughout the world, but also in this country, and that it is absolutely inevitable that humankind will do something, and it would be good for us in all sorts of ways, not least of which is economic, to get out ahead of it. And I would reorganize enforcement of existing law to make a priority out of rules that would advance climate change, arresting climate change. The second thing I would do is I would want to maintain a stable administrative state. I'd be interested in having things go smoothly, because if they didn't, then my main agenda item would get wobbly. And I think President Obama has seen that several times. The main thing I do there is reconstitute the cabinet as the main source of advice to the president. I would make the argument to Bernie Sanders, I believe, that the dramatic increase in White House staff and power is not a good thing for government. I would strongly recommend, it's going to sound weird, but one of my favorite books is Duty by Robert Gates. It's his autobiography, and he talks a lot about how even the Pentagon doesn't have autonomy. You know that if the Pentagon has no autonomy and decisions are made on a 24/7 political reaction basis, that OSHA, for example, is in really deep trouble. I would make implementation of Dodd-Frank my top priority within the administrative state, not as a bully pulpit matter, but as a good government matter. And I'm going to defer to Andrew to talk more about that. He knows a lot more than I do. Third, I would speak truth to power. And the traditional approach is to sort of slink around, hoping against hope that nothing goes really wrong on your watch. The possibilities for what could go wrong seem pretty endless to me. We could have industrial accidents in highly hazardous industries that remain in the United States. We've exported most of our manufacturing footprint, but we still have deep well production, fracking, refineries, some chemical plants, and they are not well regulated at all. Food poisoning, another possibility for a big disaster, and the threat of imported goods, and I'll mention that more on that in a moment. So all of those things are things that could embarrass President Sanders. I would say that he should instruct the agencies to write reports on how short they are of funding and how much they cannot do unless their funding is increased, because they are at this point so thin on the ground that from my perspective, we almost don't have effective regulation in many areas. I mentioned OSHA. FDA is also having serious problems, and EPA is feisty, but still struggles with these things. Finally, new frontiers. What would be my concerns about areas we have not covered at all that we need to step up? Imports is one. We have no effective regulatory state when it comes to inspecting imports. 80% of the ingredients of the drugs we take are manufactured abroad. 20% of our diet is imported. I urge you to read Professor Coglianesi's book on imports that he edited with other people is very stimulating, and I think that needs to be very important priority. Energy production, fracking, big priority. Cybersecurity, obviously, big priority. And finally, the impact of global competition on safety culture. I think if we understood more how businesses are organized and what incentives they must cope with, we would be, because of globalization, we'd be a lot better off. So with that,
Great.
I hope I've gotten everybody alarmed,
So,
especially Paul, my friend Paul.
but there's no problem with the food safety for those of you in the room today. Don't worry about that. We hope. We hope. Paul, lots of sweeping areas of regulation that Rena mentioned as priorities. Are those priorities you share, or do you think there's something that might cut across all of those areas that you want to see the next administration take up?
Thank you, Carrie, and thank you for the invitation to be here today. I would hope that the regulatory process in the next 5 years focuses on a more overarching issue, which is how does the process as a whole best enhance societal well-being? And I'm a proponent of cost-benefit analysis, and I think the next president has a wonderful opportunity to strongly advance the cost-benefit state. There has been a remarkable degree of consensus among the three branches of government on the use of cost-benefit analysis for rational regulatory decision-making. It's striking how in the executive branch, the executive orders that have directed agencies to balance benefits and costs since President Reagan through President Obama are remarkably similar in their language. The Congress itself is very interested in this issue now. There's legislation in both the House and Senate on this issue of legislatively implementing a cost-benefit state. And the courts have actually opened the door, I think, for the next president to take a much stronger step forward than has ever been realized. For 20 years, the Supreme Court had a presumption against agencies using cost-benefit analysis to implement regulatory statutes. They basically said that unless the statute clearly called for cost-benefit balancing, they weren't going to find agency authority to implement the statute in that way. That changed pretty dramatically, in my view, in 2009 when the Supreme Court decided the Entergy versus Riverkeeper decision, where they jettisoned that presumption against cost-benefit balancing and brought this issue into alignment with the basic principles of Chevron, which is if the statute's clear on its face, then that's the end of the matter. Congress has spoken. But if it's silent or ambiguous, then the agency's interpretation of the statute will be upheld as long as it's reasonable. And the court concluded that it was eminently reasonable in the case of a statute that was actually silent on cost-benefit balancing for the agency to take a cost-benefit approach in implementing it. Now, as I had said, since Ronald Reagan, presidents have directed agencies to use cost-benefit balancing when they implement statutes, and they all have the same exact language, whether it's President Reagan, Clinton, or Obama. They all say, to the extent permitted by law, agencies should employ cost-benefit balancing. Problem is when you hit Supreme Court precedent saying it's only allowed if the statute clearly calls for it, that's kind of a roadblock to full implementation of that executive direction. I think now that Riverkeeper's been decided, a president could direct agencies, unless prohibited by law, to implement statutes through robust cost-benefit balancing. And the reason I think this is so important that this presumption against cost-benefit analysis was reversed is that there really aren't very many statutes that explicitly require cost-benefit balancing or explicitly prohibit it. The majority of statutes, I would argue, not only environmental statutes, but all regulatory statutes, are in the middle zone of being either silent or ambiguous. And I think under the basic Chevron principles that Entergy rests on, a new administration would have wide discretion to fully and vigorously implement cost-benefit balancing. So the next president really has an historic opportunity to dramatically advance the cost-benefit state by directing agencies to revisit their statutory interpretations and employ cost-benefit balancing and implementing statutes unless prohibited by law.
Thank you very much. Andy, you want to go next? You have any lessons learned to share over the last few years of regulation, and what would be your vision going forward?
So I want to do a couple of things. First of all, the lessons over the last 5 years. Regulation is clearly important. Markets need structure. They need policing. There is no such thing as a free market. The idea that there's a free market is a myth. It's never existed. If you think of the world prior to the modern regulatory state, where we have regulated orderly markets to a greater or lesser degree, you had the 19th century, which was chaotic railroad accidents, fraud on investors, bank panics, and before that, you go farther back in history, and we have feudal orders in Europe, and you don't have a real market at all. So we need for markets to exist, you need law, you need property, and ultimately you need regulation. Without good regulation, we know in the modern world that powerful interests will, acting rationally and in their own self-interest, take advantage of ordinary folks, take advantage of small business, and ultimately undermine their own stability and productivity. We know that from the financial crisis, and we know that from a wide range of other circumstances, from the environment to drug licensing, etc. The second thing I'd like to, so the second lesson I think we can draw from the last 5 years is that there are major obstacles that exist in the way of smart, sensible, effective, and flexible regulation. Regulatory budgets are constrained in amount and often are subject to congressional interference, where there are problematic incentives for members of Congress that get donations from lobbying interests to push narrow policy riders that constrain regulatory action. There are questions of agency capacity. Agencies are only as strong as their human leadership, and if you're asking agencies to do too many things at one given time, you do strain the capacity of the leadership to do that, whether it's concentrated in the White House or even in the cabinet or independent regulatory agencies. We have to remember, to greater or lesser extent, we're still, our agencies are run by human beings. But human beings are also taking a back seat in some cases. Unfortunately, in our technological space, regulatory agencies have not kept up. We have information collection and data analysis problems where agencies like the SEC are far behind what's going on in the private sector. I think cost-benefit analysis or economic analysis is quite sensible in theory, but it's often costly and in practice not as effective and quite frequently an obstacle in some circumstances. So it can be seen as an advantage or it can be seen as an obstacle depending on your perspective and depending on how it's implemented. And it is something that requires a much larger budget to do well. If you want to have sensible, flexible, nimble regulators, you need to deal with those obstacles. A third thing I would highlight is that regulators and regulation inherently tends to be cautious. That's probably a good thing. It probably can't be helped. It's not always true. There are times when you have bold regulations. If we think back to William O. Douglas at the SEC way back in the day, or there are other instances where people can come up with examples. But in a world where regulators are probably cautious, there's limits to what they can see coming forward and how they can address new and emerging crises or new and emerging problems before they are crises. So you get in the risk of a failed regulatory cycle where a regulator doesn't identify something, or even if they do, you have everybody saying, all the industry and members of Congress and folks complaining, oh, that can't possibly be right, don't regulate that, that's not a problem. There'll be a lack of consensus in academia, and when something does blow up, you'll then blame the regulator for not getting it right. This is a challenge. So I do think we have to remember that big decisions need to be made by political leaders, the president and Congress. Regulators are very important, but they can't do it all on their own. I'd like to spend a couple of minutes talking about what we see over the next 5 years. I do think that there's some very interesting questions about what those approaches look like. And if I can use the 4 top presidential candidates, similar to the way Rena did, Hillary Clinton, Bernie, Trump, and Cruz as frames, you start to see things, start to look different. And I'm going to pull out one division between the 2 candidates. Hillary Clinton and Bernie did not endorse one or the other, but just to highlight some of the questions about direction that are being brought to the fore and that have to be grappled with. And this is the question of Glass-Steagall versus shadow banking. So Bernie Sanders has said we need Glass-Steagall immediately. Hillary Clinton has said we need to deal with the broader range of what's called shadow banking. And what this brings to the fore is a question about structural reform driven by Congress and a statute that says we're going to divide you up into simpler, more contained, understandable sectors versus you might call it a more regulatory approach that's recognizes complexity in certain respects. It says we're going to be nuanced, tailored, and we're going to use the regulatory apparatus to get at it. And if you look at historically, there isn't I don't think you can draw a consensus to one being better than the other. We had in 1934 Glass-Steagall. It took 20, 30 years for the industry to figure out ways to get around it with the money market mutual funds and other things, and then you start to see the shadow banks emerge. But the flip side is, well, if you look at things like Dodd-Frank, which took a very technocratic or regulatory approach, and I'm the author of the staff drafter of the Volcker Rule, so I am the first to accept responsibility for it. It has it's harder to implement. It is more nuanced, tailored, targeted, although the goal is similarly to have a stark line between customer trading and speculative trading. And I think there are questions about, will that work and is it working? Is there sufficient transparency to evaluate whether the regulatory state is working? Is there sufficient transparency and technical understanding to evaluate whether things like the Volcker Rule, which was intended to be by its authors a modern Glass-Steagall, is it working? And if folks are not able to conclude that it is working, do you want to go back to the starker approach of Glass-Steagall? And I think that type of debate is going to continue over the next 5 years, not just in this area, but in other areas as well. I'd like to conclude with a couple more thoughts about what the next 5 years are going to look like in terms of regulatory choices. And there's lots of important regulations that need regulatory areas and markets that need to be ordered and policed, whether it's climate change or worker rights, housing markets, or a variety of other areas. We're going to see regulations come forward, but the question is, how will they be done? Will they be done via broad principles and court litigation? An example you're going to see probably starting tomorrow, from all indications, is the fiduciary duty and investment advice, where in general it's going to be a broad principle of act in the best interest of your clients, and then let the courts figure out what that means in specific details. You often hear industry saying, we want principle-based regulation. But then when you give them principle, they say, well, we want specificity. Well, which one is it? We'll have to figure that out and see how that evolves. Antitrust is a similar type of regulatory form that takes broad principle but is implemented by the courts. And you see the same tensions between clarity versus specificity and flexibility. A second approach, I would say, again, is regulatory detail. I think we'll continue to see that in a lot of the financial sector, whether it's SEC and CFTC continuing to move forward and finalize the swaps regulations under Dodd-Frank, or other types. You will see regulatory detail continue. And then I think you'll continue to see structural change, whether it's things like Glass-Steagall and banking reform, or questions about how we organize our housing markets and Fannie and Freddie. Will those be combined? Will they be split up into more pieces? Will you see other structural changes? I don't think we know exactly the answer. Underneath it all, though, I would highlight that transparency and disclosure is critical for all of these things to work. You can't really have an effective regulatory state, with very rare exceptions, without sufficient transparency and disclosure. The last point I'd make, if I could, is that there's an ongoing debate about what role for the public versus experts. And I'd highlight a book or an article by Karthik Ramana called Thin Political Markets, where he talks about the accounting world and highlights some of the tensions between those who are really, really expert in things like accounting versus the public interest, where you have broadly dispersed folks like you and me that do not have the ability or the capacity to weigh in on these hyper-technical details. How do we maintain the public trust and a regulatory apparatus that acts in the public interest? I don't think there are clear answers yet, but we're still grappling with it.
Thank you very much, Andy. I'll turn to Sam next. You've done a tremendous amount to document the accumulation of regulations in the past. What do you see going forward, and what's your vision for what that future of regulation should look like?
Thank you, Karen. Thank you for having me. In terms of a vision for regulation during the next 5 years, I'll attempt to frame it maybe in a bipartisan lens, which might sound like good news in D.C., but sometimes it's probably disqualifying from getting anything done, actually. But if you look, I think this was probably not that well covered. Obviously, income inequality is a huge issue now, and I think it will continue to be over the next few years, and it's one that I think even conservatives should put forward sort of policy priorities in that area as well. I mean, if you look back to the healthcare debate during the aughts, I think that voters had in mind that conservatives didn't have legitimate proposals to reform healthcare by reducing costs and increasing access and increasing affordability. And President Obama got elected in 2009, and the result was the Affordable Care Act, and now we talk about healthcare a lot. So maybe that was a good thing in terms of filling that policy void. So especially in the income equality front, I would like to see conservatives fill that policy void. And surprisingly enough, Speaker Ryan and President Obama have virtually one of the same proposals to address poverty and inequality, which is expansion of the Earned Income Tax Credit, which originally came about during President Ford's administration, and especially to contrast that with increasing the minimum wage or doubling the minimum wage under some proposals. Republicans, I think, can point to the Earned Income Tax Credit as a way to lift millions of people out of poverty and to encourage work. Part of the proposals, which again are pretty much identical between Speaker Ryan and President Obama, are to lower the age threshold for eligibility and to essentially double the maximum subsidy under the EITC, mainly for childless adults, because that's one area where there's sort of a gap in coverage for the EITC. And for the case that I think conservatives and progressives can make is if you look at the people who are in poverty right now, 58% take the EITC versus roughly 5% who earn the minimum wage. Roughly 1 in 50 workers earns the minimum wage versus roughly 1 in 10 who earn the EITC. So you have a much bigger pool of workers under the EITC compared to the minimum wage. And in research that my colleagues did at the American Action Forum found that expansion of the EITC, essentially Speaker Ryan and President Obama's proposal, would lift roughly 99,000 people out of poverty, drive 8.3 million people into the workforce, and those necessary effects would generate roughly $94 billion in income, and this is in contrast to roughly $13 billion in costs. So while that might be not the most attractive issue for conservatives to tackle immediately, I think that income equality will be an issue whether or not they like it, and they're going to have to put forward a proposal. This is one area where the Speaker of the House and President Obama happen to agree. Another area which, again, I think there's some broad bipartisan support is occupational licensing reform at the state level. For those of you who are unfamiliar, in some states, Louisiana, for example, florists have to be licensed. I've never heard a compelling case for why flower arrangements pose public health or safety risks. There's other states where interior designers are also have to be licensed. And if you look at sort of the accumulation of regulatory licensing laws from the 50s to today, it was at one time a small fraction, lawyers, doctors, technical professions to now where we're licensing florists and yoga instructors. And in terms of how aggressive people want to be at the federal level, there's a question there in terms of federalism versus preemption, whether or not conservatives who happen to hold both houses of Congress now want to be aggressive and start preempting state laws, or they just want to agree in principle with progressives that occupational licensing is an area that hurts the ability to move up the economic ladder and reduces available labor opportunities in favor of the flower cartel, if that's a thing. And to turn briefly towards sort of the maybe regulatory specifics, I think OIRA reform is another area where there's sort of broad agreement, especially on the transparency front. The Government Accountability Office has issued roughly 25 recommendations for reform at OIRA. OIRA's adopted 9 of them, and GAO keeps reminding them that there are these other recommendations out there. Part of them are just sort of low-hanging fruit. For example, meeting notices should take minutes or hours to post, not days, weeks, or months. OIRA should probably issue its reports when they're supposed to and not every other year. There's other issues which I think hasn't been covered that widely, but when OIRA essentially rejects a regulation, they issue a return letter. And under President Obama, they've only issued one for the ozone rule back, I think it was 2011. But they have withdrawn roughly 24 rulemakings during this time, which is in effect sort of a return letter without any transparency. Those are sort of just disappearing regulations on the back end of the IRA website. And I don't know going forward why, if there's any reason other than politics, you wouldn't disclose those reasons. Perhaps slightly less popular would be actually an expansion of OIRA's role. Back in the 1980s, OIRA had roughly 100 employees, and today they have, I think, around 40 employees. And this has been a time when we keep adding regulators. We've added the Consumer Financial Protection Bureau, the OIRA review. We've added Department of Homeland Security. So OIRA right now is roughly 40 people dealing with 400 rulemakings annually. So we're talking about a rulemaking almost every single day, more or less. And there's also the question of whether or not OIRA extends its power to independent agencies as well. Obviously, you'd have to have some buy-in for Congress on that front. But I think going forward, it makes little sense to have this sort of uneven approach to regulatory review and to regulations where, sometimes you talk to people from other countries and they say, well, half of the government has to go through OIRA review and has to have certain cost-benefit principles and has to sort of justify the regulations, and the other half, especially when we're dealing with all financial regulations, doesn't. Again, OIRA reviewed independent agencies is less popular, but I still think it's an idea that has merit. And finally, one area where, again, I think this is somewhat low-hanging fruit and there is bipartisan agreement is retrospective review. President Obama, somewhat famously, I guess it depends how closely you follow regulation, issued executive orders in 2011, 13563, 13579, and 13610, which urge agencies to modify, streamline, and expand or repeal existing regulation. And what you've seen, again, sort of this agency-led process is incredibly uneven results. You've had some agencies like the Department of Transportation who I think have been very aggressive at actually looking back at previous regulations. There's one particular rule dealing with truck drivers and no defect reports, where essentially if they were to drive from one location to the other and nothing would happen, they would have to issue a report saying nothing happened when I drove here. And Department of Transportation and the industry said this doesn't do much to promote health or safety, so they got rid of it and saved roughly 46 million hours of paperwork. To put that in context, that's roughly 15% of DOT's paperwork total. So if the IRS did that, for example, that's $1 billion. But the IRS isn't doing that, and that's not entirely IRS's fault. But there are other agencies like Health and Human Services that claim that new Affordable Care Act regulations that are implementing the Affordable Care Act are retrospective review. And if implementing the ACA is retrospective review, then you can say everything is retrospective review, I guess. But just to conclude, I think retrospective review is sort of a no-brainer, and it needs to be sort of driven up from just agency-led, maybe to another group, maybe to a division of the Congressional Budget Office, to look at 80 major regulations every year, which is what we have, and to realize that we have really good data on retrospective review for maybe 2 or 3 of them every year, unless I'm missing something. That's 80 to 90% of the regulatory world, major regulations, where we have little idea of how they actually perform. And I think going forward, sort of enshrining retrospective review should be
Thank you very much, Sam. So lots of ideas all of you have. I think that when you get a group together with this much experience, the first question that a moderator has to ask is, what do you think of each other's ideas? Is there some room, as Sam's suggesting, for bipartisan agreement on some of these issues, or are some of them ones to really to be skeptical about? Rena?
I'll be the skunk at the picnic. I think that the key thing that you heard in terms of the difference is how we regard the current status of the administrative state. And I think it's failing. To some extent, we all think it's failing. But I think it's failing because it is slow, defunded, and is not embracing the issues of the day in any kind of effective way. And that is a very different perspective than the idea that it's not thoughtful enough about how it does regulate. I'll go so far as to say that I think rulemaking is virtually dead at every agency where it is not statutorily mandated. So worrying about how I'm just being provocative.
You're just being Rena.
You don't have to embrace me just because we know we're right and they're wrong. But I'd say it's virtually dead. It's so congealed. I mean, OSHA did one rule in 8 years, one major rule. It's pitiful. Paul.
I mean, Rena, you and I probably agree on some of the dysfunctions, actually, but we have different views of how to fix them. I mean, I think sort of when you live in a world where there's a lot of priorities and there's limited resources, priority setting matters a great deal, and I think economic analysis can help tremendously there. I also think it can make some rules such clear winners they actually go forward and are expedited or even supported by politicians who would otherwise be quite skeptical about regulation. And I also think you and I probably agree on issues like some of the dysfunctions in the current regulatory system relating to special interest group politics, presidential electoral politics. And I think a cost-benefit test can cut right through that. In fact, that's why I don't want to just stop with executive action, but I think Congress should legislate it by statute, because a lot of the worst things that have happened in the regulatory state that you and I probably agree on were because of some of these dysfunctions, and I don't think they would have happened if we had a requirement by law that all regulations must do more good than harm.
Can I ask you a quick question? Let's take Flint and the lead pipes, the water and the lead pipes, and let's agree, I think we can, that the infrastructure is poor, regulatory oversight is weak, and there are a lot of kids that are being now poisoned again because of lead pipe. Going rate for an IQ point, $8,500. What do we do about that?
Well,
Would cost-benefit analysis make that situation a winner?
I think rules that have health impacts are highly valued under that kind of a framework. I mean, I'll give you another example that is a clean water example. One of the driving reasons why Congress took the step of actually explicitly putting cost-benefit balancing in the Safe Drinking Water Act when it amended it in 1996 was it had more of a command and control approach that was well-intentioned, but the idea was, we're regulating cryptosporidium, we're regulating some of these other contaminants, but there are some unaddressed issues, so let's have a statutory mandate, and let's have a requirement that, every 3 years there's 25 more contaminants listed and they got to be regulated. What happened because of that inadvertently was, we live in a world of limited resources, and those resources were diverted from known high risks to much lesser known speculative risks. And as a result, you had the cryptosporidium outbreak in Milwaukee where 400,000 people were ill, and over 100 people, I think it was 131 people, died because of that. And again, it was because of this lack of priority setting. And it ought to be, this is the other thing too. I think one of the things our regulatory system gets criticized for is that it's not sufficiently evidence-based, okay? And I think if you have a framework like that in place, it actually drives the creation of better information, whether it's scientific or technical information, and that's going to make the regulatory process, I think, much more effective.
I invite Andy and Sam to jump in too.
Yeah, I found myself both agreeing and disagreeing with Paul here, and I do want to highlight something that the Rena brought to the fore, which is I totally agree that priority setting is absolutely critical, and that we do need very strong evidence-based regulation. And I actually would agree that economic analysis has been helpful at times to improving how regulators do their job. There's no doubt about that. The thing that I find worthy of thinking, or the challenge in this is when we, and you know, you're in law school, so this is where you have to be thinking about this. What is the role of mandating this in law and putting the courts, getting the courts involved, and striking down regulations because of administrative foot faults or not doing enough tests, or having judges like in the Business Roundtable go and question how the SEC did economic analysis, and what I think the result is you see that layers of costs and time devoted towards more, and people complain about the length of the regulation, the 300, 400, 1,000-page regulation. A lot of that is chewed up with explaining these things, where query whether we could bring economists into the process, have a more evidence and thoughtful-based system where you do have additional transparency, but doesn't make sense for the courts to go in and second-guess that.
And Paul, do you want to respond to that? Because I think,
I'll do it
and then
briefly,
we'll
but
turn to Sam here.
I see some experts in the room,
Okay.
so I hope we get to it in Q&A
Absolutely.
as well. But my brief response would be, I can't imagine any more fundamental requirement that doesn't deserve to be in law than a direction to agencies that are supposed to promote societal well-being to do more good than harm. And, a lot of these analyses, you talk about the delay, Andy, but the analyses are already done. They're just done poorly. And there's not an incentive for the generation of the highest quality information that would be there if you had this in a more formal framework. I'll leave it at that for now,
Okay,
Carrie, and
sure.
hopefully for the room.
Okay.
I would add one more thought. I don't disagree with much of what you said, but I would add one more thought, that a lot of the times regulators are dealing with unknowns. And they've got to make judgment call, and certainly even under the most rigorous economic analysis, you don't. It's not like you can weigh this cost against this benefit always. Sometimes it is, well, we know these costs, we don't always know these benefits, and we've got to figure out judgment and whatnot. And there's times where having more specific evidence helps, and there's times where you may want to take certain approaches that if you take a numerical approach because that is the best judgment you have, if you don't have the economic analysis to comfortably back it up, you start having regulators worry, well, can I really back that up in court? How much will the court really defer to me? So there's tensions.
And this is, to just segue over to Sam and his point about retrospective review, it's an opportunity actually to build that evidence base to reduce some of those uncertainties. And if you are making judgment calls ahead of time, does it make more sense then to look back and check, did we make the right judgment call?
Yeah,
Sam?
sure. Some have called it sort of a positive feedback loop, that in every piece of legislation going forward, Congress should put down certain principles, certain metrics for success for regulation. And there was a project that the GW Regulatory Studies Center did a few years ago, which I commend, looked at whether or not in final rules agencies were putting in metrics that would allow you to even judge whether or not there was success or failures. Because believe it or not, and we've tried this, and we're actually trying to hire someone right now whose job would just be retrospective review. It is not easy to go back and look at a regulation as simple as it would be look back at CAFE standard from the 2012 to 2016 rule and judge whether or not those are success or failures. And partly that's because of the upfront work by agencies installing these metrics in regulation. But I mean, if you just look back at where we've been over the last 5 years of regulation, now, especially with maybe the rulemaking is 5, 6 years old, you get a chance to have some good data to judge whether or not these rulemakings are succeeding or failing, and you should want to know. I mean, every progressives, conservatives should want to know whether technology-based standards or performance standards are working, and learn from the ones that haven't succeeded as well and amend them, and learn from the ones that have succeeded and use those as examples going forward.
Rena, does Bernie Sanders want to know? Or should he want to know as well? Do you want to?
Bernie Sanders wants to do something about climate change.
Okay. All right. That's a great point, and banking regulation and all sorts of other things too. So let's open this up to your questions, and we'll take it from there. Go ahead.
So it seems that every time a new rule is created or a new regulation passed, that creates a significant cost for businesses, large and small, that's indeterminate. It, forces these departments to hire a new team of lawyers and regulators and bureaucrats, and it gives these new powers to government departments that often are not, they're able to operate without accountability or transparency often. So I'm wondering, how plausible do you think it is, given that over the last 8 years we've seen thousands of new rules created, to begin rolling back this expansion of the regulatory state, and what needs to be done to do that?
I'll take a first crack at that. I think we have seen a dramatic growth in the regulatory state. Just to put it in perspective, there are about 31,000 people that are employed by the Congress. So that's Article 1 that has supposedly all legislative powers. The courts have about an equal number, about 32,000 people. In the executive branch, there's about 100 times the number of people who are employed by the legislative branch. It's about 2.8 million, close to 3 million. If you added the military, that's another 1.4 million. And I just make the basic point to just note that when you talk about who's making the laws in Washington, you need to look downtown to the executive agencies, because that's what's happening. I think what would help in the context of this vast delegation of lawmaking power from Congress to the executive branch, it makes sense for Congress to say, if there are a lot of complex questions that we want to delegate to the agencies, we're at least going to ask for some accountability. And we're going to channel your discretion in a way where we can have confidence that you're doing more good than harm and that you're enhancing societal well-being.
I've got to.
Okay.
I have to. First of all these people don't work on regulation, and of course Paul knows that. I'd actually say that the decision makers in Washington are on K Street, not in the agencies. We had 4 lobbyists for every congressional office when Congress was considering climate change, and I haven't heard about job losses in the lobbying sector. The second thing I'd say is most of the regulations that I'm aware of in the health and safety area, which is the most heavily criticized, are required by statutes. I mean, Lisa Jackson did not go into the basement of the EPA building, get drunk on her own whiskey, and come up with all these crazy ideas. She promulgated a lot of regulations because they had been dragging through the courts, especially in the 1990 Clean Air Act amendments. And then they came back, and she had to do it. She was under deadlines. So when we say that there are thousands of new regulations, I just would be wary about counting them as if they were exactly equal. I would reject any effort to say, well, there are this many pages in the Federal Register, and you have to do a qualitative analysis. And the ones that are statutorily mandated, if we don't want those anymore, we have to go back to Congress.
Sam?
And I've said that to them, and they always say to me, but we love the Clean Air Act. What are you talking about?
If you do care to count the regulations, especially major regulations, those that have an impact of roughly 100 million or more, the latest count, if you want to compare through this same point in the presidencies, President Obama has issued about 40% more than President Bush, and you can take that as, yes, he probably should have, that's way too much, or that sounds about right. If you're looking to just roll back what has happened over the last 8 years, there are of course not going to be any silver bullets. I think it's probably going to take an approach from all three branches. It's going to take a willing executive to actually go forward and through the notice and comment rulemaking process, which obviously is not easy and will take more than just a couple of years when you're depending on the scope. And it's going to take Congress. I mean, like I said, they're going to have to outline their vision for all of these priorities, and they're going to have to outline their vision for regulatory reform.
And only one quick comment. I mean, it's when we talk about regulation and all of this, we have to come back to the specifics. And if we get down to the specifics, things start to look a lot different. Do we want to repeal the regulation that lets banks gamble with taxpayer dollars? Do we want to repeal the regulation that doesn't have any type of food safety standards and E. coli problems emerging here and there? Do we want to repeal? You can name this one after another, and you start to say, well, maybe not. And so that's I think one of the it doesn't mean that there are not plenty of efforts right now to try to repeal regulations, and we sometimes see. The Jobs Act was a major repeal of the securities laws from 1933 and 1934, which kind of people didn't notice, and now we'll see whether they do it again.
Okay, other questions? Stuart.
Thank you very much for a wonderful panel. Professor Colonisi started out at the beginning mentioning a possible point of inflection that we're at, and indeed, 3 of the 4 leading presidential candidates, regardless of what you think of them, would represent a market change from the status quo. But the one who is most likely to win, at least if you believe the betting markets right now, couldn't represent the status quo anymore, Secretary Clinton. Andy talked about the difference between experts and the public. The experts on the panel seem to think that the regulatory system is broken in different ways. Does the public think it's broken? Don't they care? If they don't care, are they wrong?
So I think that I think there's some divergent views, and I think one conclusion is that I think the public is deeply frustrated with lack of economic recovery from the financial crisis and Great Recession, lack of accountability for those who caused those problems, and for just continuing regulatory violations, big and small. And I think that there's continued frustration regarding its accountability, but it's also lobbying and influence in our regulatory state and government. There was a big controversy not too long ago where Senator Elizabeth Warren called out an advisory committee on the Commodities Future Trading Commission that had issued a report critical of limits on financial institutions betting in food markets that might drive up the cost of food, or oil prices that drive up the cost of prices. The point being that there is significant concern about whether some of the institutions that are heavily influenced by insiders are not sufficiently transparent, accountable, and operating in the public interest. Having said that, we've also seen some successes. I mean, there are changes that have happened over the last 8 years that see improvements, whether it's the fact that banks are safer than they were 8 years ago. Do we need to do more? Probably, but you can see this across the board that there has been progress. So, as to the status quo versus major reform, I think that if you're on the progressive side, you probably say a little bit of yes to both, although people will be more on one side or the other side. If you're on the conservative side, then obviously I think that you're going to be critical. But even there, in things like the Jobs Act or other things that have passed under Republican Congress, you might find some, and sometimes President Obama himself has pushed forward cost-benefit analysis that has been criticized at times by those on the left might, say, well, the status quo is actually seeing movement.
Sam, did you want to weigh in on this too?
Sure. In terms of what the public thinks, I would have to speculate, but I can probably say with some certainty that 99% of them don't care or know what the Office of Information and Regulatory Affairs is, nor do and I don't really blame them that much. I think to some extent.
We won't take a poll here either.
To some extent, and you've studied this, it's sort of going to your corners, whenever I talk to members and they sort of relay their constituent concerns, it's either, one corner is the regulatory world is underserving Americans and is failing, it's taking too long to do anything. The silica rulemaking, which took roughly 20 years, which is an outlier, but still it took 20 years. And the other hand is, regulation equals job killing, and every new rule is crushing business. But I'm sure that there's a vast middle ground somewhere where that sort of wants sensible rules for the game, and has a sort of Goldilocks approach to regulation. But how they define that, I don't know.
I'd like to see if we can get some other Penn Law students. Yes, right? Yeah. Right? Yep, you.
All right. I was just wondering, there seems to be sort of increased activity, comments on increased activity in the administrative state in recent years. And I was wondering, to what extent do you think that's a counterbalancing of Congress, the sort of lack of movement there, and sort of, if there's a relationship at all?
Yeah. So if we had a more robust, productive Congress, would the regulatory state be as active as I think Sam is saying it is, but not Raina's saying it's dead.
No, it's not dead.
Okay.
It's on life support.
Okay.
But I would say that congressional approval ratings are really low, and they are acutely dysfunctional from the perspective of the American people. I think Stuart raises a very good point. That's the most dangerous thing that goes on right now. As I am worried about North Korea and all sorts of problems in the world, but having a dysfunctional Congress is really a problem for us. And so, of course, the executive branch tries to step up, but I'd be the first to admit that it's working with statutes that are outdated in my area of specialty. I mean, the Clean Air Act in 1990, nobody had climate change on their minds. So we're very, very creative, the agencies are, but it means that they're walking out on thin ice all the time. And if we don't get this Congress, I mean, I often tell my students, and then they throw the rest of their lunch at me, for you to solve this problem, you the young people. But I really think it's important. I hope some of you run for office.
Plug for public service is always appreciated.
If I could add one point about that, if you look at the CFPB, which I think a lot of people feel is the
Consumer Financial
Protection Bureau, is an example of a regulatory success. We can debate about that. But the vision for it was that Congress cannot keep up with all of the innovative ways that the industry uses to change different financial products that can harm consumers. So, and they've got all the lobbyists and the gridlock and different views. Sometimes gridlock is simply disagreement, and that may be a good thing if you don't want the thing that you disagree with to pass. But the idea of the CFPB being we need a nimble regulator who will use the regulatory power to protect consumers. And so from that perspective, and I think a lot of Dodd-Frank and a lot of some of the ACA is different, but the healthcare reform is different. But just taking Dodd-Frank, yeah, the regulatory state is designed to be more nimble because Congress cannot keep up with all of the changes that go on.
All right. Paul?
I'll just say this. I don't want to let Congress off the hook because I think they themselves should apply a little medicine to themselves, cost-benefit balancing in their consideration of statutes. And they do criticize the executive branch a lot, but they are the ones delegating all this authority to the executive branch. And I'd like to see them take more responsibility for that.
I agree with that, by the way. I completely agree with that.
I think we all agree. But if you talk to...
Amazing. That's wonderful. I just didn't want that moment to pass.
If you talk to House and Senate staffers, though, they'll tell you that it's really difficult because they'll say, we can draw, I'm sure, I think the Volcker was like a page and a half in text and wound up being like 500 pages in regulatory text. They'll say, we can sort of draw a blueprint, and then it's up to the regulators to sort of fill in the brick and mortar, and then the brick and mortar is ultimately what winds up during an oversight hearing or in court.
Allie.
So we talk a lot about different tools for reforming regulation, whether it's cost-benefit analysis or whether those with any real effect takes a lot of resources, which takes a already pretty cash-strapped, as Rita pointed out, agencies, that's to be close or depending on your perspective, but that have a lot of regulations already to enforce and to carry out. So what is your, I mean, you represent the spectrum, what is your perspective of breaking through loggerheads in order to, is there support for putting money into actually funding those initiatives like cost-benefit analysis or retrospective review or what have you, in order to actually create a more efficient administrative state? And do you think that there's political consensus on actually coming behind that?
So just for the benefit of those watching by live stream, let me repeat that in case it doesn't get picked up. Generally speaking, we've heard these ideas about improving the evidence base, cost-benefit analysis, retrospective review. How do agencies do that when they're already strapped and taxed with a lot of other responsibilities?
I would offer Paul a deal. I would say, if you give me more money for enforcement of existing laws, and we could even talk about which areas, then I will support your effort to get more money for cost-benefit analysis.
You accept the deal, Paul?
I think there's a deal to be had here because I think that cost-benefit analysis, which I am a proponent of, does take resources, but I think it's an incredible deal for the government to do it. You know, when I worked at OIRA, the budget there was $6 million a year. That doesn't buy paper clips at most agencies, honestly. And I think it'd be an incredible deal for the federal government to double that budget.
But Paul, I want cops on the street. I want people going to jail. I mean, don't forget my agenda here.
I think one part of having a functioning regulatory system is where there's bad actors, they need to be caught and they need to be punished.
And they need to go to jail.
In some cases, that's true. I have to be careful. You know, there have been studies on the payoff because there is a cost-benefit analysis. But one EPA study I remember said they viewed it was 1,000 to 1 payoff. And anytime you get 1,000 to 1 payoff on anything, you should make the investment. I think it's money well spent. And again, in many cases, analyses are done. I'd just like to see much better quality. And I would like to see better staffing, not only for OIRA, but to have a good regulatory analysis functions in the agencies and departments.
Adam, you've got a question.
Yeah, it follows right on the last one because I was going to make the point too about the payoff. I think we may disagree what they are, but we have each of us visions of billions of dollars in net social welfare waiting to be extracted, and it's often for the want of millions of dollars of analysis. But you know, I like your deal. I don't know why you wouldn't support more money for cost-benefit Rita anyway. But you know, if there's a precondition, that's great. But the money to the agencies, not to
doing
OIRA.
a deal with Paul.
Yeah, I mean, it would be nice to double OIRA's budget, but much more has to go to the agencies to actually do the good. So my question for Paul is, I like what you said about, and this gets back to what Rita said about inaction. You know, you said all regulations must do more good than harm, and I guess I would just challenge you. What about the corollary? All regulations that do more good than harm must be done.
Yeah,
is there
that's
a way to identify those things and say, instead of sunset, sort of sunlight, that it has to go into effect because we know those billions of dollars are out there, and something's not making it happen. Let's have an automatic it happens.
Yeah, and this is where I think it's exciting because I think you would see this rare alignment, right, where liberals and conservatives would come together on this idea of making government work better. That's a win-win for anybody, no matter what perspective you come from. And I think that potential is there. I agree with you with the unleashing of enormous value there, benefits in all forms, whether it's health, safety, the environment, economic value, everything.
Andy, you want to?
Yeah, I mean, I guess I would just add that we have to be careful with practical realities. So agencies are run by individual or commission leadership, and there are constraints on human capacity to digest multiple issues going on. So, you know, when you do have additional demands of additional analysis. You start to see these obstacles that I mentioned that come up in a very practical way for preventing agencies from implementing things more quickly. And to the extent that we want to have nimble regulators that can make tailored, nuanced regulation, there's a trade-off with having obstacles and process that goes along with that. If you want to have regulations that are more, cut and dry, or are not as tailored, or are just, we're going to be more cut and dry, then yeah, they don't need to move as quickly. But they're, so those are the things I'd add.
Sure. All right.